was not working. And I appreciate your candor on that. And, you know, I agree with Mr. Hamilton that, you know, what happened to the Monroe Doctrine? And as you stated, sir, with all the, like when I was growing up, it was coming from Mexico primarily. Now, you know, when I chaired Homeland, even if there were a handful of special interest aliens or a handful on the terror watch list, that was a big event. And I remember Secretary Jay Johnson and I talking about who are these people. But now you have 7,000 special interest aliens and almost 300 on the terror watch list. Those numbers alarm me and concern me. To Mr. Hamilton, you were the one, you were the legal architect for the Migrant Protection Protocol program, Remain in Mexico, working both at Department of Homeland Security and then later my old alma mater, the Department of Justice. What I was interested in, this is not some new law. A lot of people think this was like some, you know, sort of novel approach by the Trump administration, when in fact, the law had been on the books for nearly 30 years. And that is under the INA 235, Section B2C, the federal statute. Can you explain to the members? I mean, this is like, you're taking a 30-year-old federal statute and you're implementing that statute to achieve security at the border. Can you explain how you did that?
Well, thank you, Mr. Chairman. It's an important point that you make, because precisely that 8 U.S.C. 1225 B2C authorizes the program that we know as Remain in Mexico / MPP. That was part of a broader package of enforcement tools that Congress provided in 1996 in IRA. There was a whole host of tools that Congress provided in that statute, including another one called expedited removal. Now, of course, the administrations didn't use expedited removal in any kind of meaningful sense, truly, until the Bush administration. And even then, they only did it for a limited population and a limited time frame. And so what the whole thinking here is, when you use a program like MPP, is to take the tools that Congress provides you, and you respect the laws that Congress has said they have created, and you use those tools to create security and to create a situation that works for the United States. And the whole point here, as I said in my opening statement, is that the whole goal of anyone crossing the border, very few of them are actually true asylum seekers. Most people are just opportunists. And that's just how it is. Folks are coming here to seek a better life. They are not actually seeking asylum. So you can put their claims, you can make where the rubber meets the road is when you say, well, if you want to pursue your claim, you're going to do it, but you're going to do it by waiting outside of the United States. A lot of folks abandon their claims. A lot of you call their bluff. And the folks who were truly oppressed and were truly persecuted were the ones who stuck it out and had their claims adjudicated.
And imagine that, enforcing the laws that Congress has passed. That's simply what this is, a 30-year-old statute. And it worked. In 3 months, you had a 62% decrease. And we were on the path to finally securing this border until the new administration came in. Secretary Wolf, you saw this under your watch. Now we have 7.5 million encounters. God knows what we're going to do with them in the United States. 300 special interest aliens, 300 terror watch list, hundreds of thousands of fentanyl deaths, human trafficking larger than I've seen in my lifetime as both a federal prosecutor and chairman of Homeland. Do you believe there's a direct cause and effect between the rescission of this program and what we currently see today? And I associate myself with Mr. Hamilton's words. They know better. Secretary Mayorkas knows better. And that goes to intent. They know better and they don't care.
Well, without a doubt, I would say absolutely. There's definitely a causation there. And it's not just MPP. It's, you know, all the other programs that were torn down, whether it's the asylum cooperative agreements and a number of regulations. You know, during the Trump administration, that all worked together as a system. Some were more effective than others, but it was a patchwork of policy programs and regulations that helped secure that border. And as each one was taken down, starting with MPP, but others were taken down as well, we started seeing the unraveling of the border. And you could say, well, maybe they just didn't know better. Well, that's not true. We briefed them during the transition. We told them exactly what would happen if they started tearing down these. You would run out of Border Patrol space. You would run out of processing. Everything that we see today, we talked to them. This is what's going to occur. And of course, it happened anyway. So absolutely.
Can I follow up because my time's running out? What if the administration had not changed? And this may get to Mr. Isaacson's point about detention space and infrastructure on the border. What would have, in implementing MPP, had the administration stayed in power, what was the plan?
I'll take a first stab. Obviously, we had implemented MPP a handful of months. So that would have been a program that was started, and so we would continue to improve it. We would continue to see more facilities along the border that were hearing MPP cases. You would have seen, better facilities there that both ICE, USCIS officers, attorneys would be in, immigration judges, VTC'd in. You would have seen conditions in northern Mexico. We were working with the government of Mexico, other NGOs there to improve those conditions. I think overall what you would have seen is the program continuing to progress to get better and better over time. When we implemented, obviously it was at the very beginning.
Mr. Hamilton?
Mr. Chairman, I completely agree with Mr. Wolf. Look, one of the things that's missing at our ports of entry in terms of physical infrastructure are spaces for immigration courts. And that's one area in which we could have made massive improvements. And I think that likely with the work of working with folks in Congress here, that could have been an actual possibility. And in fact, creating an actual immigration court facility at every single port of entry along the northern and southern borders, you would have had a much more streamlined situation and on top of all of the things that Chad discussed.
I couldn't agree with you more. Mr. Isaacson, what do you think about that approach if we had the courts at the ports of entry?
If you had the courts at the ports of entry, people would not have time to prepare their cases. They would not be able to get the evidence they needed. They would not be able to find counsel. It takes due process usually is.
No, if it's in the United States ports of entry, due process would have to attach and apply because it's under the Constitution of the United States. So my time's expired, but I respectfully disagree. And I know you're in an outnumbered situation here, but I'll recognize Mr. Sherman.